this evening's docket. That is case number 114705, Rochelle Patterson v. Cowley County et al.
Good evening. As I indicated, my name is Jeff Carmichael. I'm with the Wichita law firm of Morris, Lang, Evans, Brock, and Kennedy. I'm here tonight to represent the appellant, Rochelle Patterson, mother and next best friend of Gavin Patterson and Nicolette Patterson. I'd like to reserve, if I could, 3 minutes for rebuttal.
3 minutes is granted.
Thank you very much. I would also like to, if I could, add a little bit to the explanation that Judge Wheeler gave about this case. I'll give a little bit of brief background and explain how we got here before I get into the legal arguments about why we think the case needs to go back to the district court for trial. This is a case involving wrongful death in which Jason Patterson, who is the father of my two clients, who are minor children, was killed in an auto incident in southern Cowley County on November 19th, 2010. What occurred was that Mr. Patterson had recently moved to Cowley County and was unfamiliar, I believe, with the county road system there. It was after midnight. He was returning back from Oklahoma. He'd been down to, I believe, one of the casinos with a friend. The friend's car, he was a passenger in, and they were proceeding east on 322nd Road in southern Cowley County. As that road heads to the east from Highway 170, it is blacktop, but then after a period of time turns to gravel, and then lo and behold, the road runs into the Arkansas River. There were absolutely no signs, no warnings, no barriers, nothing to indicate that the road would intersect with the Arkansas River. The car in which Mr. Patterson was a passenger was going approximately 10 to 12 miles an hour and attempted to stop at the edge of the river, and there was an abrupt 12-foot drop-off into the river. Evidence showed that the car, basically, the SUV that they were in, attempted to stop but could not, and the front of the car went over the embankment, and it was almost straight down. The vehicle went down and landed on its front end and then flipped onto its top, into the river. The upriver side of the car had a window open. The car quickly filled with water, and both passengers in the vehicle drowned. That is why we are here. My clients believe that that is a wrongful death claim in which they're entitled to recover damages from the township and from the county for failing to have adequate warnings, adequate signage as to what was going on that road. And I believe that's what occurred. Then was a motion for summary judgment by all parties at the district court level. The district court granted summary judgment on a majority of the claims against my client and held and ruled that because there was substantial likelihood of disagreement, that there was a basis for an interlocutory appeal. And so an interlocutory appeal was granted in this case. The Court of Appeals affirmed what had occurred. We're now here on a petition for review, asking the court to review that decision and to reverse what was done at the Court of Appeals and the district court level to send this case back for trial. You know, one of the things that this case primarily deals with is the Finkbinder case, in my opinion. It is a case very factually close to the facts and circumstances of the immediate case. In Finkbinder, there was again a township road in which a person was driving a vehicle, and the road abruptly dropped off into a dry riverbed. In that case, because there was no water, they didn't drown, but they were injured. And they filed suit. Factually, I think the cases are almost indistinguishable. Township roads.
Other than the fact that the parties stipulated to their township's responsibility, which, as I read that case, I'm uncertain that it really helps you that much the way it's worded. But and let me ask you specifically. We're here to decide immunity. And as I look at this, it's a question of law. Would you agree with that?
immunity?
Yes.
It can be a question of fact. but-
Well, question of law for our purposes, is it not?
Well, I think what the court has said is you look at the totality of the circumstances, which makes it a jury question. So I'm not sure I agree necessarily that it's an issue of law. I mean, if your question is, can it be resolved solely by the court without any factual issues being considered, I don't think that's appropriate.
And the factual considerations in this case would be the uniform manual, is that right?
I'm sorry,
The uniform manual.
yeah, MUTCD,
Right.
the Model Uniform Traffic
Yeah,
Control
man-
Device.
Yeah.
And I think what you run into in looking at that particular case, and you mentioned the issue of the stipulation, I think if you read the opinion, what they stipulated to, I believe, was not responsibility for signage, but rather who had jurisdiction over the road. And the question in the Finkbinder case was it the county or was it the township? And I believe that they all agreed that it was a township road, and so stipulated to it. But that does not address the issue, and there was no stipulation as to what the impact of that factual finding would be. And that's why I believe, Your Honors, that the issue is, what is the responsibility of a township and the county in this situation to have placed signs on that road? What the district court ruled was that because of some changes of statutes that had occurred in 2003, that Finkbinder had effectively been overruled. And that again was an opinion that was discussed by the Court of Appeals. You know, one of the things that I would do is if I'm concerned about whether a case has been reversed, I would go shepherdize it and see, you know, is that case still good law? And there's nothing to indicate, we checked again this afternoon, to indicate that the Finkbinder case has been reversed in any fashion. The district court, in essence, ruled it's been overturned. You haven't said so. The Court of Appeals said it's been overturned. You haven't said so. And it's a Supreme Court opinion. And I don't think there's any basis for you to do anything other than uphold what you did in that case.
Well, then tell us why we shouldn't overrule it. I'm over here.
Sorry.
Tell us why we shouldn't overrule it based on the 2003 changes that are pretty explicit as saying that a township is not a local authority.
Well, I think there's a number of reasons, and one is you need to harmonize all of the statutory provisions that are in play. 8/2003, 8/2005, KSA 68, 101, KSA 68, 526. All of those, when read together, need to be interpreted in a fashion that allows all of them to have purpose and to remain in effect. Keep in mind that 8/2003 is the adoption of the MUTCD as the law of the state of Kansas. And the MUTCD says whoever has control over the roadway is responsible to place signs.
But the manual can't give authority to the governmental unit, can it? Doesn't that have to come either from the Constitution or the state statute?
It has the same effect, because it's statutorily adopted, it has the same effect as law. That's exactly what the Court of Appeals held, that's what the district court held. That the MUTCD, when it's adopted by KSA 8/2003, has the impact and effect of law. And that's exactly why, if you read it together with the other provisions, the only way it makes any sense is for the amendments in 2003 to give special privileges and powers to 5 counties, the populous counties in this state, but not to take away any obligations for the other counties who are in the non-road unit system, the 31 counties who are in that position. You know, to adopt the position and the argument of the defendants in this case would mean that there are 31 counties in which all of the township roads are simply at risk, Nobody has any responsibility to place signage, to do anything with those roads. It's the wild, wild west.
Why
When you drive on those roads,
wouldn't
do
the
so at
counties
your own
have,
risk.
why wouldn't the counties have responsibility?
Because they're not obligated to by statute. They can step in if they want to, they're not obligated to. That's a specific statutory provision. They're not obligated to take the place of the townships, but they can, but not obligated to.
Which statute places that, or absolves that responsibility?
I believe, Your Honor, I don't see it right in front of me, it's the one statute that says that if the township doesn't place signage, the county can step in and do it, but they're not obligated to do that.
That's the same 8/2003, that's at the end of the statute, says
Correct.
that, but you're saying that that only applies to that 5 counties giving special permission to them. What generally otherwise would preclude the counties from having responsibility?
I believe that's the provision that would give it, Your Honor, that they're not required because they don't have jurisdiction and control over township roads. They have control over county roads, not township roads.
But that statute talks about 5 counties.
Correct. And what I'm saying, Your Honor, is that there are 5 counties that were granted special privileges, and it says,
I understand what you're saying, but the
Right.
statute says in these counties, the township shall have responsibility for putting up basically warning signs and can put up regulatory signs if the county commission authorizes it.
Correct.
And then it says the counties only have responsibility to, or they may do it, but they're not obligated to.
correct.
And why wouldn't that last sentence that's in the same statute apply just to those 5 counties?
Because I think it's referring to the original statute that, before that amendment was added, I believe, which,
How do you construe it that way? What possibly would send us anywhere else other than the preceding sentences of the same statute?
well, I believe, Your Honor, that provision was in place before 2003. The amendment in 2003 added the 5 counties, which I believe is subsection, I believe it's B, or excuse me, C. No, it was B. And my point, Your Honor, is if you take a look at that provision that was added in 2003, it says that the townships in Douglas, Johnson, Riley, Shawnee, and Sedgwick counties, which are the most populous counties in the state, were given the right to add regulatory signage in their jurisdiction. And there could be a really good policy reason for that, because in the most populous counties, people are moving into the rural areas, and you're going to have homes in areas where you didn't have homes before. Personally, I live in northern Sedgwick County, in an area that was at one time rural. It's now fairly urban, with lots of homes being built out there, and the township might want to have the right to put up speed limit signs or other types of regulatory signs that they wouldn't necessarily need in a less populated county. And the statute says that it talks about those 5 counties can place those signs, but it says, in addition, such townships shall place and maintain regulatory signs. And what the key language there is, in addition. It gives the grant of those 5 counties not only the right to do that, but in addition, the right to place regulatory signs. Now, if the defendants would be right in this case, if it was just the first sentence, if all it said was, in townships located in Douglas, Johnson, Riley, Shawnee, and Sedgwick counties, the township board shall place and maintain traffic control devices other than regulatory signs on township roads under the board's jurisdiction, period. If it ended right there, the defendants are right. It's only the 5 counties. But it's not.
You're way over time, and we have a number of issues before us this evening. I think we've been concentrating on just one.
Yes.
So let me ask this question to move us off this issue. Tell me why the recreational use exception does not provide an immunity for the county in this case.
Because everything that occurred in this case occurred on a county road, not in the recreation area. The incident that we're talking about, the failure to have signage, the failure to provide warning, all occurred on a county road or a township road, on the roadbed, in the roadway, not in the recreation area. There is nothing to indicate that anything that went wrong in this case went wrong in a recreational area. The fact that there was adjacent to this roadway the Call Wildlife area is irrelevant to what happened on that road, irrelevant to why those folks were there at 1 or 2 o'clock in the morning. It has nothing to do with recreation.
And is there a case that you would greatly rely upon for that position?
I believe, Your Honor, we cited several cases in our briefing that talked about that it needs to be incident to, it needs to be integral to the recreation area. This roadway was there long before that recreational area ever existed. The roadway was there since 1880s. The recreation area came into existence in the 50s. And so the road was not integral to nor a part of the recreational area.
So you'd be relying in part on the K-State case and the restroom in the football stadium?
Correct.
Mr. Carmichael, before you sit down, I have another question that's unrelated to the issues you were discussing earlier, or at least tangential. And that is, I'd like to better understand where the failure to conduct an engineering study fits in to your case.
Sure.
Whether it's standalone as a cause of damages or just a feature of the non-discretionary duty exception argument.
I believe it's the latter. I believe it's a portion of the non-discretionary duty. And keep in mind too, Your Honor, that the engineering study was an amendment to and change in the 2009 version of the MUTCD. It was new. So previous amendments or previous discussions of the MUTCD that don't reference it for a reason, because that was a change in that version of the MUTCD requiring engineering studies to be done as a condition to and as an understanding of what needed to be done. Totality of the circumstances then would require an engineering study to determine where signage should be placed, and that's what should be reviewed in determining whether there's been a violation by either the county or the township in this case. I didn't mean to go over time.
Well, we were peppering you with questions, so it's
And I
not your
appreciate the
fault.
questions.
All right. Thank you, counsel.
May it please the court, counsel. Again, my name is Charles Millsap. I'm from Wichita, represent Cowley County in this case. Let me first say it's an honor to have our case here at this special setting. I've never argued in front of this many people, so I like it. I want to talk about two things today. A little bit about the discretionary function immunity, which the Court of Appeals reversed the district court on and instructed that we get summary judgment on. And then I also want to talk for a few minutes about the rec use immunity. I'm going to use 12 minutes of the 15 minutes of time. So if that clock gets to 3 o'clock or 3 minutes, I'm using my friend's time, and I will stop. The discretionary function immunity is it often comes up in these cases, and I will say it can at times be a difficult thing for the court to deal with. I think the district court here had a difficult time kind of combining an analysis of all the various cases we have on that and came up with a solution that's tied to proximate cause, which hasn't been argued since then. It was our position, and it is our position today, that when we raise discretionary function immunity, the question is, we look to the source of our duty, which in this case, without a doubt, is the manual. I'll just refer to it as the manual. And we ask ourselves this question: is there a ministerial, non-discretionary duty inside that manual which has the force and effect of law that required my client to do something which the plaintiffs say we should have done, which could have had some causative effect with this accident? We're ostensibly sued for not putting up a dead end or no outlet sign about a mile away from the scene of this accident, and or not putting up an advisory speed placard warning that you should slow down as you approach this particular location. I say ostensibly because even the plaintiff must recognize when we get inside the manual, there is no place to find a mandatory duty to do either. I won't belabor this, but we do argue, and the Court of Appeals picked up on this, the answer to this question lies inside the manual, where the authors of that come up with 3 types of practices which people in my client's position can look at when it comes to signs. One is a standard or a warrant where the manual says if this set of conditions exist, you shall, and that's the word they use, you shall install this sign. You don't do engineering judgment. You don't have to do an engineering study. You shall do it. It's mandatory if you do that. There's a second category called guidance, which the Court of Appeals also mentioned as a warrant. And what that says is a recommendation. It says if this set of circumstances exists, you should, and that's the word they use there, you should install this sign unless engineering judgment tells you otherwise. And that, in our view, is the area where engineering judgment and non-discretionary wouldn't be mandatory, but it would be a place where you would say something like was said in the Carpenter case, which I'll talk about in a second. But the third category is called an option, and it's called an option for a reason. And the authors of the manual define that as a practice that's neither required nor recommended by the authors, but is merely a permissive use. And you might say to yourself, well, big deal that they say it's permissible use. You can put up any sign you want. And before you read the manual, you might think that, but in fact, that's incorrect. Under the manual, you may not put up a sign that's not in the manual unless you go through this process of getting an experimental approval by the Federal Highway Commission. As it turns out, both types of signs that I mentioned right here are options under the manual. The Court of Appeals picked up on this. If we're searching, doing this search that I talked about to determine whether there's a ministerial non-discretionary duty to put these signs up, the answer is in the manual. We look to those specific sections, and when we see it as an option, we know that the manual has told us that that's not a requirement. Matter of fact, it's not even a recommendation. It is an option, a permissive use.
Counsel, let me just interrupt you and kind of
Yes, sir.
back up to the question I keep stumbling over, and you've used the phrase several times, non-discretionary duty. Is there such a thing as a discretionary duty?
That's a good question. I think there may be, I think I could make an argument that there are duties to, in certain circumstances, exercise discretion. But before I was done talking about that, I would point out that our legislature has determined that when it comes to clients like my client, when they do that or when they don't do that, that there's going to be immunity. And I won't belabor the source of that immunity.
Well, right, but that does cut to the heart of your argument, does it not? Because if it's a duty question, arguably it involves fact questions that are for the jury. But if it's not, if it's, as you've argued, it's a question of law that you can be awarded summary judgment on. I mean, so that seems to me to be a really key dividing point.
I agree, Your Honor. But again, the manual has the force of law. I think it should be treated like, almost like a statute. And I'll give you an example of where this court wouldn't have trouble finding discretionary function. If I were here representing someone from Cali County that decided not to arrest somebody, I would raise discretionary immunity as a defense. And this court would pull out 22, whatever it is in the criminal code, and read the arrest statute, which says that a law enforcement officer may arrest someone under certain circumstances. And the court would say the use of that word may creates a permissive condition for that law enforcement officer, and he would have discretion whether or not to arrest.
Just to cut to the chase, your argument, as I understand it, is if the manual doesn't require the government entity to do something without exercising any discretion, then it's immune.
Right.
That's the only instance in which the county can become liable. is if they fail to do something that the manual explicitly tells them to do and doesn't give them any discretion.
Right, or as the court often says,
So that, again, just to be clear, because in many situations, the county and the engineers and the people who make these decisions are exercising discretion. And typically, we would consider that to be a matter of a person who has a professional duty to exercise reasonable care within the context of their profession to make good decisions.
right. And in the manual, that's the guidance section. I mean, that's.
And your argument's just the legislature has decided that counties are immune when they perform that function.
Discretionary functions, right. And I don't know how better the manual could describe discretion. Yes, sir.
Let me clarify how you're interpreting the manual to go along with my colleague's question. If the manual requires it, then discretionary function doesn't apply. And so if there's a standard, obviously discretionary function doesn't apply, correct?
Right, a standard as defined by
Okay,
manual.
and if there's a guidance and an engineer says it should be or it's required, then that also negates discretionary function exemption, correct?
There are people that argue that. The Acosta case, which was an
Well,
unpublished.
you were just arguing,
Right.
you said that a guidance, it should, unless an engineer says it needs to be there.
Right.
What happens if an engineer says it needs to be there? Does that take on the status of a standard?
I think if I were sitting in your shoes, what I would say, that takes on the status of engineering judgment, which is different from exercising discretion. Now, there are people that do what I do that would disagree with that. And the Acosta case drew the line somewhere else. But in this case, the line's not drawn for either of those two. It's drawn above the option. I do want to.
And so, under the option, even if an engineer says absolutely in every situation, just like this, you must put up a sign, then there's still discretion not to do so, and the exemption applies.
Yeah, we don't have an engineer saying that, but.
Well, I'm asking you if that were the case, that your position is that there's no way that an option can ever take on the status of something that's required.
Yes, I would say that, because the engineer is not going to set the law. The manual and our legislature's adoption of the manual is going to set the law. If I can, I do want to just very briefly talk about the rec use immunity. My client was denied the use of that in this particular case, and I think we could use better law, quite frankly, than we're going to have with this. The reason that the district court found that we weren't entitled to rec use immunity is because my client wasn't involved in the design and construction of the wildlife area, although the district court found that the road leading there was an integral part. The Court of Appeals found that the road wasn't an integral part of the wildlife area, so my paved location a mile away from the wildlife area isn't in the wildlife area. And we haven't argued that it is, quite frankly. So if that was dispositive, I wouldn't be arguing that. But the whole problem with the way the rec use immunity has been applied in this case is that the statute tells us to look at the location where the injury occurred, not where the negligence occurred, where the injury occurred. And this court has said, I think it was in the Lane v. Atchison case, the one case involving the convention center and the loading dock, that this particular statute granting immunity for intended and permitted facilities should be read broadly, and Kansas courts should not impose additional hurdles to immunity that are not specifically contained in that statute. And I think both the district court and the Court of Appeals have done that, one, by requiring my client to be the one to have designed the rec area, and or by requiring the statute to be applied based on where the negligence occurred, as opposed to where the injury occurred. We've got a law review article I quote too that I think nails it. But if you read the statute, it talks about an injury that occurs during the use of property.
So the victims of this accident were using the river? I mean, is that your argument?
Well, absolutely. And they were using an area that contained the river. In this court, again, in the Lane case, said an injury need not occur during the course of...
Maybe I misunderstood, but I understood you to say that if the use was of the roadway, you would not be advancing this recreational use argument.
I'm sorry to interrupt. If the use of the roadway was where the accident occurred, well, if it occurred in a wildlife area, which is uncontroverted in this case, that it did, then I would be asserting that. But what we're simply asking the court is to interpret the statute and apply it based on where the injury occurs as opposed to where the alleged negligence
You're making a
occurred.
distinction between the roadway and the river.
Right,
Okay.
yeah.
Well, aren't
So-
you making a distinction between the intersection of 111 and 322 versus the riverbank?
Absolutely,
Okay.
yes. All right.
So just to go back to Justice Steele's question.
Okay.
Don't worry about
All
the
right,
clock.
I'm
It's our
trying to
clock.
protect my friend.
All right.
All right,
We'll save him time.
all right.
To go back to his question and looking at the statute, any claim for injuries resulting from the use of any public property intended or permitted to be used as a park, playground, or open area for recreational purposes.
Yes,
And your position is that once they have left the roadway and they are in the river, they're using the property? Or are you saying they were using it when they were driving through the wildlife area, or what are you saying?
they drove into the wildlife area. In the wildlife area included I call it a dirt path. It's a road because it was laid out 140 years ago all the way to the road. But there's no question that the last several hundred feet of that path are in the Kaw Wildlife Area. They just are. And we don't know why these people were there. It doesn't matter if they were there to recreate or whatever. The fact of the matter is, and the district court found it, and it hasn't been challenged in this whole appeal, that these injuries occurred in the wildlife area. We know that because the state of Kansas got rec immunity in this case.
So
We
they-
didn't because of the reasons that I pointed out.
They were using this area, the wildlife area, and therefore the rec use exception applies,
That's
simply stated.
right, yes.
Okay, so just driving through an area is using it, even though you're not yourself using it for recreational purposes? I'm just trying to get clarification. here.
Right, yeah, and I mean, sometimes that occurs. We've got several examples of rec use immunity application where people weren't recreating, whether they're walking down the hall from a swimming pool or in the restroom at K-State or walking through a grassy swale on their way to a football field. Those people weren't recreating, but they were using in the sense they were there when they got injured. And that, at least from our position, is the clear import of the rec immunity statute that our legislature has drafted.
All right, thank you.
Thank you, Your Honor.
Do we have any further questions? Thank you, counsel.
May it please the court, counsel. Again, my name is Ed Keeley, and I represent the defendant, Holton Township, which is also the appellee in this case. As this court knows already, the township was granted summary judgment by Judge St. Peter below, and that ruling was affirmed unanimously by the Court of Appeals with the opinion written by Judge Standridge. We submit that both of those opinions are very well reasoned. I want to address just a few of the arguments that plaintiff's counsel has made here tonight. First of all, plaintiff's counsel emphasizes that there were no warning signs, but it's uncontroverted as found by Judge St. Peter that there had never been any accidents in that location on that unpaved road, and there had been no complaints to any governmental entity regarding that unpaved road, which was naturally in a very primitive situation or state because it was in a wildlife area. I mean, the people that used that were hunters and fishermen and people that liked to go out and just be in a wildlife area, observe wildlife. So that's the first point. Second point is Finkbeiner whatever the law was after Finkbeiner, it was changed by the 2003 legislative amendments. The legislature very clearly had three options and considered all of them. The first bill, the original bill that was introduced, would have codified Finkbeiner. It would have said all townships and non-unit counties have the duty and the authority and duty to place all kinds of signs, all traffic control devices. And it's important to note the definition, statutory definition of traffic control devices includes both regulatory and warning signs. So the original bill, as it was submitted, was simply townships, it's your road, you have to sign warning, you have the duty to sign regulatory, everything. That was changed, revised in the House under the clear legislative history, which is in the record in this case, because the counties, in particular the Kansas Association of County and Douglas County, said, hey, that's not the practice. Our practice in these urban counties is for the townships put up the warning signs, but when you're talking about stop signs and speed limit signs, which townships don't have any way to enforce, they can't, they have no ordinance power. In those situations, the counties want to be involved and they want to essentially either do it themselves or approve whatever the township wants.
Counsel, is it your position that the statute is vague and ambiguous?
The 2003 amendments to both 8205, 2005, which added subsection C, and the amendments to, I think it was 68, 256, which added subsection B, or 562, I'm sorry, 68, 562. Those are two added provisions to the law as it was under Finkbeiner, are clear, plain language, unambiguous.
Then we don't need to worry about what the legislature intended.
That's exactly right.
Okay.
That's exactly right, and that's the point. But if you want to delve into the legislative history, I mean, it's also absolutely clear there. What plaintiff is arguing doesn't make sense. That, these amendments just gave special powers to townships in these 5 urban counties with respect to regulatory signs. Well, but as far as all other townships in non-urban counties, like Bolton Township, they would still, under Finkbeiner, according to the plaintiff, have the duty to place all signs, the warning signs and the regulatory signs. And as Judge St. Peter pointed out, that doesn't make sense, because basically then you got the rural townships with the least expertise having more duty than the townships, urban townships in the urban counties. And that doesn't make sense. So the only way to, as I've said, is plain and unambiguous. So basically, we asked this court to affirm the Court of Appeals. This is a legislative matter. As this court has said many times, public policy is made by the legislature, and when it's plain and ambiguous, that's the end of the story. This court doesn't rewrite the statutes. And so if people are concerned or they think this particular 2003 amendments don't serve the public purpose, then they're free to go to the legislature and have them changed. But that hasn't happened since 2003. Thank you.
Very well. Thank you, counsel. You're reserved 3 minutes for rebuttal.
I recognize that I went over, Your Honor. I'll try to be brief. Let me just point out, on the issue of whether the roadway all the way to the river was part of the Call Wildlife area, it was not. And as part of the record, it shows that there was a grant of this section roadway, and the grant in like 1888 was all the way to the river. It wasn't anything other than a roadway all the way to the river. Someone saying now that a part of that roadway is part of the Call Wildlife Area is absolutely not true. The grant was all the way to the river on the section line, and that's exactly what the roadway was. Now, can you say that my client's father was injured in the recreation area? No. Did he wind up after a collision and where he should have been on the roadway? Yeah, he wound up in the river, but he never should have been there. There should have been barriers, there should have been signs, there should have been warnings on the roadway to stop that from having occurred. That doesn't make it a recreational activity just because that's where he happened to wind up after this unfortunate event. With the issue of totality of all circumstances, if you take a look at our expert report, which is Exhibit M to our motion for summary judgment from Tom Alcorn, he points out that this is not a cut and paste manual. You can't take the MUTCD and walk up to an intersection and go, yep, here we go. This is supposed to have this sign here and this sign here, because it requires engineering expertise, which is why the 2009 version of the manual requires an engineering study in every instance. Finally, with regard to the issue of the interpretation of the statute, I contend that it is not clear that the intent of the 5 counties was simply to give them a special grant of powers to put up regulatory signs, but warning signs are required by every township in the state of Kansas. If you don't have that, you're going to have anarchy out there, chaos in terms of these roadways with nobody being responsible for them. Nobody you can look to say, you should have put up a warning sign that there was a problem here. And that, I believe, is the opinion from Finkbinder, which is still good law in this case, which is still good law in the state of Kansas, which says there's an obligation, because like this case in Finkbinder, they also noted there were no prior accidents, no complaints, but the court still said there's an obligation to make sure that you, in the totality of the circumstances, have acted appropriately in failing to place those warning signs, and there was a cause of action allowed in that case. We would ask that the case be returned to Cowley County for trial on all issues, that the Court of Appeals decision be reversed, that the decision of the district court be reversed, and all claims that we've asserted be allowed to go forward. Thank you.
Thank you, counsel. We thank all counsel for your arguments this evening. Court will take this matter under advisement.